Yo, I don't know what's going on in Congo.
Yo,
For real.
Same.
I still haven't
read
read
Lockman's
it.
Legacy. Like I still haven't read it.
what is that?
Mood.
I just don't understand why commercial speech is different than like regular speech. Like, why can't it be the same thing? Like, I don't understand. I don't understand the difference.
These cases get so complicated. I mean, they're interesting because they're about gambling and alcohol, but it sucks. Like, I don't get it.
Maybe we should read in case we get cold called because you know sample.
No, what we should do, we should Google it and like maybe look
Quimby.
up
No,
some-
Quimby
Quimby sucks.
Can I borrow your login?
Yeah, sure.
Alright.
No, but we got the outline from last year's group.
Oh,
We got that
outline.
kid got an A+, right?
Yeah, me too.
Yeah, can you share that?
What's everyone's email?
Just send a group email.
Okay. You
No.
guys, I think we should like learn it on our own. Maybe we should like YouTube something.
Oh, that's a
like,
good
see
idea.
what pops up from other people maybe.
You really think people are going to be reporting about commercial speech?
Yes, they should. They gotta take the class, right?
All
You
right.
never know. We should give it a try.
All right, I'll look it up. Let's go.
YouTube.
www.youtube.com. Commercial speech.
Anything?
Actually, there's something here.
Is it good?
I don't know. Let's take a look. Did I not see?
Oh, go ahead, Leslie.
All right.
Hello, my name is Dominique, and I'm here with my co-hosts, Destiny and Louise.
So you're in Professor Sample's common law class and confused about commercial speech.
While he's teaching, you may say to yourself,
Why is he yelling?
oh, he's still asking me who decides.
And what does an ox have to do with con law?
Well, we're here to help.
Welcome to Black Letter Law.
The commercial speech edition.
Congratulations, you made it to the commercial speech portion of Professor Sample's common law. So what is commercial speech?
Commercial speech is where the speaker is more likely to be engaged in commerce, where the intended audience is commercial or actual or potential consumers, and where the content of the message is commercial in character.
In the case of Central Hudson Gas and Electric Corporation versus Public Service Commission of New York, the Supreme Court of the United States instituted a four-step analysis for commercial speech to the Commission's arguments in support of its ban on promotional advertising. First, is the expression protected by the First Amendment? Second, is the asserted governmental interest substantial? Third, does the regulation directly advance the governmental interest asserted? And finally, is the regulation more extensive than is necessary to serve that interest?
Now let's take a look at how commercial speech has been addressed in Supreme Court cases.
That taxi ride took forever.
But look at the hotel, it's so pretty.
I know, it's beautiful.
Hola.
Hola, señoritas. Bienvenidas al Hotel Gasparini. Mi nombre es Vanessa del Carmen Constancia de Rodríguez Carrasco. ¿Cómo les puedo asistir?
Hi. Repita.
I'm sorry, do you ladies speak English?
Sí.
Well, welcome
Yes.
to the Hotel Gasparini. My name is Vanessa del Carmen Constancia Rodríguez Carrasco. How may I help you?
You mean
Checking
Vanessa?
in. Vanessa. She said Vanessa.
Yeah, Vanessa or Vanessa, that's fine.
Okay, we're checking in.
Okay, ladies, how was your flight today?
It was long, but it was okay.
And where are you coming from?
New York.
Oh, I hear it's really cold out there.
Super cold.
It's not that cold.
It's cold.
It's okay.
Well, you're in Dora weather, so welcome here to Puerto Rico. So lately we've been around 85, 90-degree weather, so you guys
Oh
shouldn't
my
be enjoying
god,
the
that's
sun.
amazing.
I need to get some sunscreen.
I need a tan.
I'm already tan.
So some of the things we have here at the hotel, we have a rooftop bar. Beside a rooftop bar, we have many restaurants and bars. But most importantly, we have a casino here on the other side of the lobby. Now our casino has slot machines, blackjack tables, our poker is live, no computerized poker tables. You get unlimited drinks while gambling at the
Oh, I'm there. Count me in.
So So now, right now it's 3 o'clock, so the casino opens around 5 p.m., 6 p.m., and we're open until 5 a.m.
Okay, so we're gonna go to the casino at 5.
Can we go to the pool first?
Yeah, so we got 2 hours to
Okay,
go.
okay.
One last thing, ladies, we have a special drink for the night. It's called Sampletini.
Sampletini.
Yeah, trust me, it's very good.
Okay.
I don't
Okay.
think I like how that sounds.
Me neither.
Try it. You guys should definitely try it. So here are your access cards, señoritas, and I hope you enjoy your stay.
Thank
Thank
you.
you.
We gotta go to the casino like as soon as open.
Okay.
And this is why Gasparilla Hotel is a place to be, because we have the best casino en la isla de Puerto Rico.
In the case of Posadas de Puerto Rico versus Tourism Company of Puerto Rico, Puerto Rico's legislature passed a law which prohibited gambling facilities from presenting advertisements like the one you just watched to residents of Puerto Rico. Tourism Company of Puerto Rico, the defendant, was also allowed to implement regulations governing casino advertisement. The regulation authorized media advertisement outside Puerto Rico subject to pre-approval by the tourism company. A policy memorandum issued by the tourism company interpreted the regulation as prohibiting casino advertisement on any promotional materials such as brochures and gift items that might be accessible to Puerto Rican residents. The tourism company imposed fines against Posadas de Puerto Rico, the plaintiff, pursuant to its policy interpretation. Posadas de Puerto Rico filed suit seeking a declaratory judgment that the law and the regulations implemented pursuant to the law violated its constitutional rights to commercial speech. The tourism company petitioned the United States Supreme Court for review. On appeal, the United States Supreme Court affirmed the appellate court's decision. In an opinion written by Justice Rehnquist, the court held it had jurisdiction and was required to abide by the trial court's narrowing construction. Commercial speech was entitled to the United States Constitution Amendment 1 protection, where it concerned lawful activity and was not misleading. Under Central Hudson Gas, the speech restrictions were permissible because they directly advanced a substantial government interest and were no more extensive than necessary. Justice Rehnquist held that 1. Statute and regulations as construed by Puerto Rico Superior Court do not facially violate the First Amendment, and 2. Statute and regulations are not unconstitutionally vague, viewed in the light of Puerto Rico Superior Court's narrowing construction of the statute with interpretive assistance of regulations as modified by that court. Let's continue with Jakara and Hamala take over Puerto Rico.
Hola, would you like a beer?
Sure. It's our preferred beer of the island.
Well, how much alcohol is in it, or how strong is it?
It's only 4.3%.
Come on, are you listening?
What?
She just said it's 4.2% alcohol in this.
Yeah, it's good. They
But-
should put some more.
But if you chug it, you're gonna get sick.
I'm on vacation, girl.
Okay. Okay, buddy.
Coors Light, the best beer on the island.
In the case of Rubin v. Coors Brewing Company, Coors Brewing Company applied to the barrel of alcohol, tobacco, and firearms for an approval of proposed labels. The approval was rejected because it violated the Federal Alcohol Administration's Act's prohibition of disclosing the alcohol content on beer labels or advertisements. Coors filed a claim, arguing the regulation violated the First Amendment's protection of commercial speech. The court held that for the government to regulate commercial speech, the government must have a substantial interest that the regulation directly affects. In this case, the interest the government intended to protect by banning the display of alcohol content on beer labels was to limit the strength wars of competing beer companies, which would lead to greater alcoholism. However, the court concluded that this interest was not substantial enough, since there was no reason to believe that banning the alcohol content on beer labels would prevent such harms. Let's continue with Shakira and Hamala take over Puerto Rico.
Girl, I told you not to drink all that beer.
I'm not feeling good.
I can tell you're embarrassing me. You stink. Throw them in the trash, not on my tongue.
I've had those samputinis.
And I told you not to drink the Samputini, and I told you not to chug that beer. But in the bin.
So do they have a pharmacy, or did the receptionist say that there was like a pharmacy or something?
I think so. All hotels have like a medicine place, I think.
Yeah, I'm gonna need some Tylenol or something because I don't feel good.
Oh.
It's not funny. You're embarrassing.
Prudenti. Welcome to Prudenti's Pharmacy. Here we have our first medicine. It's Lochner's Cure for Headaches at only $5.99. Our second medicine that you can find at our pharmacy is O'Connor's Remedy for the Stomach Bug at $8.99. And lastly, if you've been partying a little too hard on our Isla, you can find Scalia's Cure for the Hangover at only $6.99. For any other needs, please visit me, Dr. Jessica, at Farmacia Prudenti.
In the case Virginia State Board of Pharmacy versus Virginia Citizens Consumer Council, Inc., the Virginia Citizens Consumer Council challenged a Virginia statute that declared it unprofessional conduct for licensed pharmacists to advertise their prescription drug prices. On appeal from an adverse ruling by a 3-judge district court panel, the Supreme Court granted the Virginia State Board of Pharmacy review. The court held that the First Amendment protects willing speakers and willing listeners equally. The court noted that in cases of commercial speech, such as price advertising, freedom of speech protections apply, just as they would to non-commercial speech. Even speech that is held for profit or involves financial solicitations is protected. The court concluded that although the Virginia State Board of Pharmacy has a legitimate interest in preserving professionalism among its members, it may not do so at the expense of public knowledge about lawful competitive pricing terms.
We hope this short video clarified some things for you.
Stay on the lookout for more videos from our colleagues teaching other subject matters of common law.
Good luck, future attorneys.
And that's all from Black Letter Law, the commercial speech edition, a special report on NBC. Until next time. Well, that was helpful.
It really was. It was.
Much better than Sable's cost.
Yikes.
I mean, even though we learned about these cases, I hope I don't get called on.
Yeah, me neither.
Yeah, me
Well, he's been looking at our road recently, so I'm not sure. Louis, you might be on
Don't
his
jinx
radar.
Yeah, girl, come on.